Hello and welcome to today's webinar on the EU Draft Directive on Platform Work. A very warm welcome to our audience. Thank you very much for joining us. It's a pleasure to have you back. Also, a very warm welcome indeed to our guest speakers today. We're very pleased and very privileged to have Julie Van Kerckhoven, Senior Manager, Social Law at Van Havermaet in Belgium. Julie, a warm welcome to you. So lovely to see you and thank you for joining us.
Thank you.
And we're also very pleased to welcome Lucas Stuurop, partner at Lexence in the Netherlands. Lucas, thanks as ever. So good to see you. How are you doing?
Likewise, yeah, very good. Excited to have this discussion today.
Well, it's an exciting topic, and as we found out in our prep session, it's a topic that could make people's heads spin. So hopefully, we'll bring some clarity and certainty to the matter. As always, guys, both Lucas and Julie are here to give their opinion only. What they say in the call should not be taken as legal advice or acted upon as legal advice. It's their opinion only. So that's our disclaimer today, and we've got that out of the way. The webinar is being recorded today, so just to let you know that, and please consent to that. And if you could mute your lines, we'd really appreciate that. And of course, if you have any questions, please direct them to the chat function, where Connor Lavelle from our marketing team will be taking questions. It's our intention to have 10 to 15 minutes at the end to take questions from our audience. So again, folks, thanks so much for joining us. Just by way of introduction, my name is Connor Heaney. I'm the Managing Director at CXC Global in EMEA. So thanks so much for joining us. I think before we get into the substantive topics, folks, I think it's fair to say that the gig and platform economy has been under what could be considered serious legal assault over the last 10 to 12 years. And also, I think it's fair to say that it's been a sector that has been unregulated and has suffered from a lack of primary legislation or law. And we've seen a large number of cases, particularly over the last 3 years in the UK, Netherlands, Belgium, Spain, Italy, and more recently Ireland, in relation to workers seeking to be reclassified from independent contractors to employees or to have some sort of worker status. So, Lucas, if I may, would you mind just giving an overview of the case law to date in relation to digital labor platforms or driver platforms in the Netherlands, and just maybe give some examples of the recent case law there. Thanks, Lucas.
Yeah. Thank you, Connor. I guess the best examples are the Uber and Deliveroo cases, which operate, of course, platforms in the Netherlands. The Deliveroo case has also gone to appeal, and there have been diverting assessments of that matter. But the latest in that is that in the appeal, it was actually determined that Deliveroo is the employer of its workers that do food delivery. That has a lot of consequences, and the assessment there is that's of course very interesting, and mainly based on the way the algorithm works in basically rating the workers and dividing the work. So it has brought basically a new reality in which the position of the platform companies is really starting to look increasingly limited in the means of operating a platform with the use of freelancers instead of employees. Yeah, and the coming time will be interesting to see if there are new developments in that respect, and if this will indeed become a settled case law that applies to the whole of the platform sector, or that these are, that these will need to be reviewed separately, all of them. And in that sense, of course, the whole directive that is looming over this discussion is very interesting and also to see how this will impact those existing discussions and of course the platform economy in the future.
Thanks, Lucas. I can't wait to get into it, because this is a meaty, complex, topic that has the potential for volatility, uncertainty, complexity and ambiguity in the European Union labour market. And Julie, over to you. Would you mind talking about the recent Deliveroo case in Belgium and any other lead cases in this space? Thank you.
I can actually repeat Lucas' words. Here in Belgium, there is also the Deliveroo case, which is pending again for the Court of Appeal, because the public prosecution has appealed its case. The case in the Labour Court actually ruled that Deliveroo freelancers were indeed self-employed and not employees. So the public prosecution has now filed for appeal at the beginning of this year. And there is now also an Uber case pending. There is the Social Ruling Commission here in Belgium, which is like an administrative organ, administrative body, and they ruled that Uber drivers are employees. And now Uber has appealed this decision, and it's pending for court right now. Given the case law here in Belgium, we might expect some clarity within the next 2 years, or maybe even longer. So yeah, that's the uncertainty remains. But here in Belgium, we there's maybe something interesting to say about that, because with regard to Uber, they are they fall within the sector of transport. And here in Belgium, this is a protected sector, and with protective criteria, special criteria with regard to false self-employment. And so this is something different than I think in the Netherlands. Here we already have criteria, and there's a little bit, it's clear what should be absent in such an employment relationship and what should not be absent. I think this will be, it will be very interesting to hear what the court has to say about that.
Thank you, Julian, and thanks, Lucas, for the case law summaries, or at least the lead case law summaries in both the Belgium and Netherlands jurisdiction. It struck me when the draft EU directive came out in December, guys, that it was to be welcomed, because it brought a degree, at least on the face of it, certainty to workers I have described in the past as low choice, no choice, which rather crudely describes the plight of gig workers, where essentially they are shoehorned into contracts for services when in all reality they're essentially employees or some form of worker. But, and there's always a but, the more I started reading the preliminary drafting of the directive, it struck me that there's likely to be a whole series and set of unintended consequences, and perhaps the EU Commission is actually using a sledgehammer to swat a fly. And really, these are some of the topics that we're going to delve into today. But just, I think, for the benefit of our audience and the benefit of our listeners, Julie or Lucas, would you care to just give a high-level overview of what the draft directive means, which workers are likely to be affected by this, and also what is a digital labour platform? Because the definition on the face of it seems straightforward, but the more I read it, it seemed very wide, and that could be problematic for non-digital labour platforms as well. So Julie, are you happy to cover that, or Lucas, would you?
I will start, Lucas. You can interrupt me whenever you want. Yeah. So the directive, indeed, its goal is, its official goal is, of course, firstly to create better employment conditions for platform workers, but also, and that was quite interesting to read, to increase legal certainty for those platforms, digital platforms, and to ensure more flexibility for genuine self-employed people. That's how they wrote it. So I'm quite curious what Lucas thinks if this directive will achieve that goal. But that's the goal of the directive. And for obtaining this, they implement 5 criteria, which a digital platform must respect. And if not, then there is a legal presumption that the platform will act as an employer and not merely as a digital platform anymore, but actually as an employer with all consequences, of course. But that's up to national legislation, of course. So that's in short the impact of the directive. Those criteria are quite interesting, actually, but I don't know if it's now the time to talk about these criteria already, or do you say?
Yes, yeah, I think so. I think it would be great for our audience just to get that next level detail of understanding.
The definition, of course, of what is a digital platform, that's up for discussion. The definition is not quite clear, but those criteria which are implemented, those remain vague as well. But those are a little bit familiar to me, because in Belgium we have already a similar system in place. The first criteria is that a digital platform can no longer determine or set limits for the level of remuneration of digital platform workers. They also cannot require the platform worker to respect specific binding rules with regard to appearance or conduct. They can no longer supervise the performance of the work or the quality thereof, which is very weird to me, because in my opinion, everyone ensures the quality of the work they outsource to a service provider. Then the fourth criteria is that a platform, of course, cannot restrict the freedom of a platform worker, including through sanctions, to organize the work or to choose the working hours. Of course, I think that's very logical. And then the last criteria is that the platform cannot restrict the possibility to build a client base or to perform work for any third party. That seems very logical to me, but I think the 3 first criteria are up for this, or food for discussion, and are less clear than the last 2. I don't know, Lucas, what you think about that?
Yeah, no, I mean, if you look at the objectives, I guess the first one basically is to create legal certainty for the workers on their employment status. Are they independent contractors, freelancers, or are they employees/workers? I mean, the second is also, there's also something about transparency of the algorithms that make the assessments and apply the control functions on the workers. But I think the main topic here indeed is the assessment of the status. I mean, if the aim is to provide certainty, it should, in my opinion, also leave a little bit of room for both sides of the aisle. Basically, 2 types of workers, freelancers and employees. But if you look at the criteria, these are so broad, and I mean, they encompass such a large part of what I would call also typical freelance work. So that my question here is, you refer to a sledgehammer. I would say throw the baby out with the bathwater. And the big question is if the effect will not be that a too large portion of the workers will also be deemed automatically deemed employees. And I question whether the mechanism or the instruments currently proposed are proportionate to the objectives and the quite reasoned substantiation of the proposal. So that is my big concern there. So I guess, Julie, I concur with your analysis of the 5 points. 1 or 2 are quite easy to accept, but the others are more difficult to comprehend.
I agree, and I also agree that those criteria are not specifically related to an employer-employee situation, and I believe that these criteria are actually determined with the Uber and Deliveroo cases in mind, and not with any other platform in mind. And that brings us to the definition of the platform, indeed, which is not clear at all. I think I already told you, Conor, that if you read the preliminary works, then I believe it's not the intention to apply this directive to all kinds of platforms, just such as CXC Global, for example, or any other platform which mix and matches supply and demand for employment. But if you then read the definition of what is an actual platform according to the directive, then I believe those platforms cannot automatically be excluded. And so that's not clear. So it starts actually at the beginning with questions. But so that's for something to discuss, I think. And I think this is only a proposal directive. So let's hope there will be some clarity once there is an actual directive.
And also to further comment on that, I mean, if you read the rationale behind the directive, the intention is not to introduce a universal definition of employeeship. It is just a mechanism to switch legal presumption in case of platform work, whatever that exactly might be. But I mean, the effect it might well have is that this will be used as a definition, especially in platform situations where this definition is so broad that it will encompass a lot of work. For example, and the third one is the supervising or verifying the quality of the results of the work via electronic means. If you're talking about algorithms that actually effectively control the outcome or the way employees or workers are carrying out their services, I would understand. But this definition is so broad. I mean, is it also via email, or if you have a handheld device which confirms whether you correctly installed a unit somewhere? Does it also apply? And also, if you look at the local legislation, I think this will create a lot of challenges to effectively implement this, because if you look at Dutch law, the definition of an independent contractor, a contract for services, and it's not really a clear definition. But if you look at the rights of the client always has the right to verify the quality of the results. If you hire a painter, you would want to make sure that he painted the house in the correct color, right? For example. Does it also certainly fall under the employer state? Those questions arise to mind, and there's only a few specific examples of very clear points that will probably lead to a lot of discussions, and therefore might not the objective of making this very clear and easy to assess might not be achieved.
Yeah. I think that's fair summary and fair comment from you both. And I thought just came to mind there. So let's say we look at a matching platform that matches labor with client demand. So Upwork or Twago or one of the 500 other labor platforms that are out there. So typically those platforms act for an end user or end client. So, big bank B, large pharma companies C, they send their job vacancies to the platform. The platform matches the job with the person, right? So in the UK, they brought in IR35 legislation and they brought it into the private sector. And what essentially they put the onus on determining whether a worker was inside or outside IR35 on the end user. For me, this is quite problematic, this draft directive, because it's putting the presumption and the responsibility, as I understand it, on the platform. But where is the end user in all this? Because the end user will essentially engage directly or indirectly the worker, right? So how does that work? Can it work?
Yeah.
I totally agree. I had the same remark, Connor, and I actually was thinking it can actually lead to an employee having two employers, I think, according to Belgian law, that is, because you have, on the one hand, our current law with regard to false independency. Where indeed, if the end user is exercising authority over a self-employed person, the end user will become employer, even if the platform is the in-between person, and if there's no direct contract between them. If this directive is implemented into Belgian law as well, then in my opinion, it may lead to the situation where we have two employers. If there's an end user and the platform who indeed supervises the performance of the work. So indeed, I share your concern there that it's not clear how this will play out in practice.
Yes. Lucas, what's your thought on that?
I guess it would actually require at least from the perspective of the Dutch regime, would require an in-depth analysis of who exercises factual control. And of course, that doesn't really make the situation easier. But under Dutch law, there are no clear criteria on how to determine whether employment relation exists. The Supreme Court has determined that there needs to be a holistic assessment of all factors, and even at the intention of parties isn't really relevant. So you need to assess all the facts and circumstances. So in this specific example, you have a very complex situation where you have to weigh in who will be the employer in that sense. And it might well be that the conclusion is that there are two employers, but which of course is in principle not possible, because you can only be employed on the basis of one contract with one employer in that sense. So it's it's complicated.
It is.
And I guess to add to that, also this is exactly the point which I believe also mentioned earlier. Who is actually the target? Because which group of workers is at risk of being put in a position with low paid position with no rights? Is that the group that finds an employer or a client via these boards, or are those other groups of workers? And shouldn't the directive be more focused on those specific groups of workers instead of the whole of the platform economy, which it now basically does?
If I just may one moment, Connor, sorry, because I heard Lucas say something interesting, that in the Netherlands, the intention of parties, the choice they made to become independent workers or employer-employee is not relevant. And it's the same in the directive. Article 3 indeed states that the correct determination of the employment status should be based on the facts relating to the performance, and not on the wording in the contract. And it's totally the opposite of what Belgian law states. In Belgium, the starting point is the attention of parties as it appears in the contract. That's the starting point of everything. So I'm quite curious how this can be aligned with Belgian law, indeed, because the approach is totally different.
Yeah, correct me if I'm wrong, but I guess the directive then totally eradicates or annuls the whole Belgian way of assessing this, because it removes the intention of parties as well to a large extent, right? So,
yes.
Yeah, that would be interesting to see.
The starting point is different, indeed. Yeah.
Yeah.
Yes.
I think though, Julie and Lucas, you're on to a number of problems that we can identify with this directive and some of those unintended consequences. So on the face of it, I think from my perspective, the directive is a good thing. It wants to protect a certain portion or segment of workers, right? But I think the impact of it has went too far. And I think Lucas was on to something there, that you've got the low choice, no choice workers that are typically on lower paid contracts, either of agency work or of independency or freelancing. And then you've got the high choice, high paid workers. She or he can essentially negotiate where and when they work. They're typically freelancers, registered as a ZZPer or registered as an independent contractor in Belgium, Netherlands, Germany, Ireland, UK. They've got the financial risk, they've got the appropriate insurances in place, they've got an appropriate agreement in place, they've got potentially multiple sources of income, right? My view is that those workers should almost be discounted from this directive. And I think, Lucas, where you were going was quite interesting, because there was a draft proposal in Netherlands around ZZP workers that they would have at least a minimum hourly rate, if I'm not mistaken. And maybe that's where the directive needs to go. Look after those workers that have the least choice, the least rights, the least negotiation power, and leave the market to look after the market. Now, I'm a capitalist, but I'm also pro rights. I believe that the most vulnerable in society should be protected. So I think we've got this dichotomy between high paid, high choice that will be captured potentially by this directive, and then low choice, no choice, low paid workers that need to be captured by this directive and need to be protected by it. Would you guys agree with that rather crude summary?
Yeah, and I definitely do. And indeed, you're correct, referring to a currently discarded proposal in the Netherlands, where you would basically have an opt-out if you earned above a certain fee per hour. You would simply have the option to contractually opt out of the whole discussion of being employee or not. You would basically definitively be a contractor as long as you keep working in accordance with what you agreed on paper. But unfortunately, that has been removed, and it has been replaced now with a more broader, holistic draft tool, of which is also quite uncertain if it will be implemented. So in the Netherlands, we are still also really searching for a way to make that work. But indeed, if the aim is to provide certain groups of workers with certain rights, such as a minimum wage, social security, a safety net, working time regulations, etc. The question is whether this instrument really achieves that, or whether this is the correct instrument to achieve that. But you can also, and I believe, Julie, you can fill me in there, but in Belgium, they have actually quite a good system in place. Even if you are an independent contractor, you still have part of those protections. You still have to pay social contributions, etc. So part of the problem would then already be solved, in my view, if you just put in place a safety net for example, a certain category of low-paid freelance workers. That would be maybe an easier way even to create those protections and safety nets for the group that you aim. James.
Yeah, I think I agree with what you're saying, Connor, that ideally it should be the case that independent workers enjoy social protection as well, and that this can be guaranteed, which is the case in Belgium. There's a minimum protection here. As a self-employed person, you pay contributions on a quarterly basis, and you enjoy social protection with the acceptance of unemployment benefits, but everything else is covered. And still, we have the discussion here. And still, they claim they are underpaid, underrepresented by trade unions, etc., and their interests are not represented as well. So I don't think it's a great solution. Also, I'm actually wondering if the European Union would be competent, but this is an open question. I have to look it up. I have to look up if the European Union would be competent to rule something about social security for independent workers. I don't think they're competent to do so. I also agree. I don't agree with Lucas because we talked about it yesterday about the opt-out possibility. I see someone in the chat is commenting on that as well. I don't agree with that because we need the legal certainty. I think platforms need it. I don't think they want to go to court every year. That costs a lot of money as well. It's bad press. So I'm not a big fan of the opt-out because I think we need a legal certainty, but I agree that the definition of the directive had to be more clear, and I think they should have dared to limit it to gig workers, which is indeed different from talent workers. We had that in a previous podcast, so it's interesting for all of our company for the company to listen to as well. But indeed, the gig workers who, indeed, it's not important who does the work as long as the work is done, low based, and then you have the talent workers there. It's very important. They're highly skilled. You hire them for their skills, and I think the directive should have made this distinction. I think if you read the preliminary works, they're aware of it, but then in the definition something went wrong, and the scope of the directive, I think, indeed is too broad to achieve the goals that it sets.
Yeah,
and to comment on the question, Connor, sorry, shall I comment on the question that I saw in my screen?
Yes, please, Lucas. I think that would be helpful. Thank you. Yeah,
so the point made is that allowing workers to opt out would lead to workers opting out to save for the payroll taxes. Of course, that I agree that could be a risk. But this could also be limited by increasing a threshold. For example, what we propose in the Netherlands, that you're only able to opt out above a certain fee or wage, and so you take away the incentive maybe for lower paid workers to make use of that to get more money in, but then putting themselves into trouble later on when they don't have the corresponding social security protections. But you can also still, issue a directive basically stating that the national tax legislator has to implement mechanisms to evaluate whether or not that is a correct opt-out or not. So you can still manage, I guess, at least above a certain threshold, manage that is not abused in that sense. I'm also not saying it's the miracle solution, but I think it's one of the options we have to make it more nuanced in that sense. And I guess Jeffrey Nukin is also asking what the true objectives of the EU directive are. I don't think catching tax cheating is one of those. It's definitely creating protection of workers that are now working as working as freelancers and not enjoying minimum wage protection as regards to working hours, sick pay, etc. And yeah, they want to create a more level playing field, I guess, for workers who are disadvantaged by working on certain platforms as a freelancer.
Thanks, Lucas. And guys, I just wanted to look at the presumption of employment. So as I understand it, there's the 5 criteria that Julie very helpfully mentioned and outlined, but at its base form, the workers will automatically be presumed to be employees. Isn't that problematic where you have that bona fide freelancer or talent worker that Julie referred to, that worker that has taken on the financial risk, they've got a BV structure, or they're registered at the Dutch Chamber of Commerce as a freelancer? Where is their right of appeal in this if they're automatically considered an employee? What does that do to their company status or their status as a freelancer in Netherlands, in Belgium, in Ireland, in Poland as a B2B? Is there anything in the draft directive around that, around the worker's right of appeal? If she or he wants to say, well, actually, I'm not an employee, I'm actually a freelancer.
I just want to say that if you read the definition of digital labor platform, it mentions somewhere the organization of work performed by individuals. So I'm actually quite wondering, if you work with a company as a freelancer, does this directive apply to you? That's a good question, Connor. So let's start there. First, I think you can indeed say that the directive does not apply to you, but of course we must see how national legislation will implement the directive, of course. But here in Belgium, and I understand from Lucas that it's different in the Netherlands, but in Belgium, for courts and social inspection services, it's not an obstacle if someone is an independent worker through his own company. The person behind it can automatically be qualified as an employee, and the company can keep existing. It's just the natural person itself who will become an employee, and all the consequences are for the employer with regard to social security, regularization of end of year bonuses, vacation, holiday pay, etc., etc. It's all risks are for the employer. So little to no risk for the person behind a BV company.
Yeah,
Okay.
it's a really interesting question, Connor, as well. Indeed, in the Netherlands, an individual can also have a company. There's no legal differentiation between the company and the individual in that sense. So that's different than I understand that it is in Belgium. But of course, the directive focuses on an individual assessment. However, these platforms usually work with the same mechanism. So, for example, if you have a platform with 4,000 workers, it's not really feasible. You can't really understand or see it clearly how, if one worker is deemed to be an employee, what the impact would be on the other 3,999 workers working on the same platform. Will there also be an individual assessment of that particular case? Or will the general assumption be, well, it's the same algorithm, the same platform, so you are now all employees? And does it also mean, and this is a very interesting question, that all those workers are forced into accepting being an employee, which also means in the Netherlands, you have to work in certain rosters, you cannot refuse assignments, you have to accept wages based on collective labor bargaining agreements, for example. The impact on your net income, maybe investments you have made will suddenly be can suddenly disregard because they will not be of any use as an employee anymore. So the impact thereof is very very high, also for a lot of people that might not even want to be and have good reason for not wanting to be an employee, because they've made investments, they've made a sound decision on being an entrepreneur using one or more platforms. Also, that's a really interesting question. My assumption or my assessment of this is that there will be a big discussions in the beginning of after the implementation, and afterwards it's clear which platforms are not employer and which platforms are, based on their specific algorithm, and then the discussion might end, and this whole legal presumption effect is also just a temporary one and used to define which companies is and which company is not a employer. I mean, yeah, so and I'm not sure if that effect is desirable.
Yeah, I'm actually wondering, I have a question for you, Lucas and Connor. I have a question, how is it in the UK and the Netherlands? Here in Belgium, a judgment can never be a general statement. So it's always linked to the parties involved and only applies to them. So if it's between a platform and one platform worker, then it only relates to the platform worker and cannot be a general statement. So it has to be like a class action, actually, if you want to make this a general something. I'm wondering how it is in UK and in the Netherlands. Is the same principle apply, or?
Yeah, I that's my understanding, Julia. I haven't worked in law for years, but based on my understanding of the Uber judgment in the UK, it applied to those workers that brought the action. So it doesn't have general effect but I think it has something called, going back to my legal days here, called instructive. It's instructive in terms of other cases. So let's say 20 workers at Deliveroo brought the same sort of action and the same set of circumstances. It's likely that the court would look to that previous case against Uber and take that as being instructive. So that's my understanding. And I think that the big problem in the UK is that there's a lack of primary legislation with regards to gig workers. There's something called worker status in the UK, but it's not quite clear how they're governed. Governed by the
umbrella agreements, right?
There's all sorts, and I see Julia Kermode on the call, who's a bona fide expert in this space. Julia, if you're listening and not on another call, would you care to comment on the UK position?
Hi. I won't show my video because I'm not suitable for public sight, I'm afraid, at the moment. But in terms of the UK position, it's quite interesting, isn't it? And I find a lot of this stuff is really unclear. So I'm just kind of listening in, and then I heard my name. I better just jump on. But yeah, it's in terms of kind of what will be happening in the UK. It's difficult to know because this whole discussion is the EU directive. So I don't think it will necessarily apply, but I do think that the UK will take notice of it. And I think there'll be pressure if the UK doesn't. I don't know if that's helpful or not because it's also vague, isn't it? So sorry if I'm not being helpful.
That's great. Thanks for jumping on, and sorry for catching you on the hop there.
Don't worry.
So much
Don't worry. Always happy.
Thanks, Julia. Lucas, same question, Julie.
Yeah, yeah, sure. No, so I mean, and I guess in the Netherlands also the starting point is that the judicial verdict can only bind the direct parties in the procedure. However, it's not as clear as that. In general, the starting point is that other parties might also have a beneficial effect of a verdict, but it cannot be detrimental to their position. But even that is a very vague assessment. And also what you see in the Netherlands, also in particular in these kind of cases, that some parties find a way around that. I mean, there have been some cases based on class action. But for example, you've also certain cases where they basically make the judge rule that the employees of a certain platform are, or the workers of a certain platform are employees, and of course this creates case law, which other employees can simply use and hold up their hand and say, look, the judge ruled that I'm an employee, because all workers on the platform are employees, because the platform has been obliged to apply certain collective bargaining agreement in a certain sector, and so it's an indirect effect of these judgments that in reality they are binding for the platform towards all individuals working on it. So yeah, of course, and this is my point. Once a couple of those cases have been published, is there actually going to be any room for rebuttals or discussions anymore? Because the defining argument is the way that the platform operates, and the way the algorithm works, or how the work is verified. Especially with these platforms that have these algorithms in place, this will be the same for all workers. If you're talking about the high-skilled workers, that might be a different scenario in there, and so there might be actual individual cases where that needs to be assessed. But for the larger platforms, I guess that's it will be dealt with very clearly after a couple of those court cases, and then it's just governing case law basically.
I think it's going to be a challenging time if you're a platform operator, given the wide definition that we see today. The other thought, and I wanted to ask you both this question, guys, and I know we're talking about the future and we need to see how the local legislators or countries will put this directive into effect. But if there's the automatic presumption that the worker is some form of employee, does that mean that a labour platform or digital labor platform should be registered with the Federagon, for example, in Belgium, or WADI registered in Netherlands, or should they be registered potentially with those already? What's your take on that, guys?
So for those who are not from Belgium, Federagon is the federal institution here for temporary labor, and they advise, and you have to have a membership. I think, Connor, you're referring to the legislation here regarding temporary work, right?
Yeah, that's correct. Julie.
Yes. In Belgium, you have to be recognized as an official temporary work agency. What is very specific for temporary work is that the employer's authority is transferred from the temporary work agency to the end user. And here, if you apply the criteria and all criteria are met, then indeed the platform would be the employer and indeed exercising authority over its workers. So it's not the end user. So it's not temporary work then. I would imagine if it would be the case, then we have a problem, I think, because then there's some weird logical experience behind it. But I think this directive somehow, strangely, would minimize the risk that for platforms, which is in Belgium the case, because if you are considered a non-recognized agency for temporary work, then there are severe sanctions. However, if you are requalified as an employer, then in my opinion, you cannot be a temporary work agency because the authority is with you and not with the end user. That would be the logical reasoning behind it, but you never know what the future will hold. But I think because right now, if you don't have the situation right now would be indeed that the end user would be considered the client, the employer, and if then there's a platform in between, then the platform could be considered a temporary work agency who is not recognized as such, and indeed would be risking sanctions for that. So this directive, with regard to that aspect, is a good thing. Of course, the sanctions for becoming an employer, the consequences for becoming an employer are much more severe, but you're not risking to fall within the scope of the legislation for temporary work.
Understood. Thanks, Julie. And Lucas, the same question to you, but my presumption would be that if you're operating a platform company in the Netherlands, you really don't want to become the employer of the workers, given that the employment legislation as an employer is quite rigid in Netherlands. But same question to you, Lucas, please.
Yeah, no, indeed. Yeah, I mean, there are some companies, as I believe Just Eat Takeaway has also issued a statement that throughout Europe they want to get rid of freelancers and they actually want to have employees on their payroll. The Dutch company of Just Eat Takeaway, I believe, currently also already only operates with employees. So there is already companies that do see the benefits, perhaps on having basic stuff. Staff they have on payroll, but yeah, indeed, the Dutch protection for employees is very high. It's really hard to terminate an employment relationship. There's all sorts of minimum wage right, minimum amount of hour rights per assignment, etc. So it's a really complex and heavily regulated piece of legislation you get there as an employer. As regards to posting workers, yeah, you do have basically the requirement in the Netherlands that as a temp agency, you can only be a temp agency if you bring together the clients looking for labor and the people offering labor. But it's not per se a negative thing to be qualified a temp agency, because you have a, in the Netherlands at least, because you have of employment law regulations that applies. It's easier to, for example, to offer employees more definite term contracts in a row than you would otherwise be allowed to as a normal employer. The question is whether or not these platforms would actually be deemed temp agencies given the requirements that have been recently introduced in the Netherlands. But if so, that particular part is not the problem. I think the problem is being an employer why you don't want to be an employer, at least from the perspective of those companies then. So it will be really depending on the specific platform whether or not what the impact thereof is, if they would be deemed temp agencies, and what the consequences would be. Yeah.
Thanks, Lucas.
Does that answer your question?
It does, Lucas. And sorry, I know we're drilling down into some of the detail, but I think what I wanted to demonstrate is how potentially problematic and complex this directive is going to be when it's interpreted into local legislation. And the other question that I wanted to get your thoughts on, guys, relates to the test for employment, right? In terms of whether the worker that's presumed to be an employee automatically, that she or he is truly an employee, right? So each country in the EU, as we all know, has different interpretations of what an employee is. But if you think about a platform that's headquartered in Ireland, but has borderless talent in Netherlands, Belgium, Italy, Germany, how do we get do we need a universal test as part of this directive to ensure that she or he is truly an employee in that particular country? What's your thoughts on that, either Lucas or Julie, or both?
Shall I kick off?
Go ahead, Lucas.
Well, yeah, I mean, that's an interesting point, because the directive explicitly does not intend to provide for a universal definition of what an employee is. It just creates that presumption on the basis of these 5 criteria that have been introduced for the whole of the EU. But it leaves it to the national legislator to, for example, in case of rebuttals, to determine whether or not an employee is in fact, or a worker is in fact an employee or not, based on local legislation. So it doesn't provide for a universal definition, which of course does seem a little bit problematic at the same time, because they do introduce these 5 criteria. So there are definitely going to be conflicts between local jurisdictions in the assessment of, in case of rebuttals, I would assume so. But from the perspective of this Irish company, yeah, you do have to take into account all the differences in local legislation, and I would believe that the place where the worker will be carrying out its services or its activities will be the defining point, meaning that wherever that worker is carrying out his work, that is the jurisdiction that you should take into account for the assessment.
Thanks,
I
Lucas.
agree. Here in Belgium, it also touches upon the legislation regarding social security, which is of public order. So you can never derogate from that. So every service provider, every employer must follow this kind of legislation. Indeed, if social security contributions would be due, then you must pay them.
Yeah, and also to point out a clear friction with, for example, how it goes in the Netherlands. In the Netherlands, the Supreme Court has determined, you have, as I said before, you have to have this holistic assessment of all the circumstances to determine whether or not, in fact, there is an employment relationship or not, whether there a certain employer's control is exercised over the worker. But now you are confronted with only 5 criteria, at least in the case of platform work. So how is that going to be translated into the new Dutch legislation? How are courts going to be dealing with that? Yeah, that's a big question.
Yeah, here in Belgium we have 4 criteria in general. For some sectors there are multiple criteria and 9 criteria or more. But generally speaking, there are 4 criteria. and you can only requalify. So the starting point is the intention of the parties as would appear from the contract. And you can only requalify into something else if there are elements in the global situation, that would be, which are which cannot be, how do you say it in English? I cannot find the word right now. This is embarrassing. So if you cannot find, if there are elements which you cannot, which are, yeah, help me out, Lucas. Onverenigbaar is incompatible. It's the word I was looking for, which are incompatible with the status, the chosen status. So if you have chosen for an independent contract, a contract for independent work, you can only requalify into an employment situation if there are elements which are incompatible with such a situation of independent work. And this directive, indeed, I also agree with Lucas, in Belgium as well. This is totally different because you have 5 criteria, and there is no criteria of incompatibility anymore. So this limits companies a little bit more, I think.
I think my takeaway from today, Julie and Lucas, is that this is going to be very problematic for platform operators, potentially very problematic for workers that are providing their services or being engaged by platform companies. But I think it's going to be very good for labor and employment lawyers. I hope so anyway for you guys. But in summary, Lucas, do you think this is going to be problematic for the platforms? Yes or no?
Oh, well, definitely.
Yes. And Julie, same question to you.
Yes.
If there is coming a clear definition of platform, then I don't think it's too problematic. But we need a clear definition. It must be more clarified than what it is right now. Yeah. If not, then indeed it will be problematic and give rise to a lot of discussion.
I think so, guys. Going back to my own legal studies, there was this great phrase in English law that you could drive a coach and four horses through this particular definition, because it's so broad and so wide. And I think perhaps that's a good way to end the webinar today. Lucas and Julie, thank you very much indeed to you both for your expertise and opinion. I won't call it advice because of the disclaimer at the beginning. We will link your respective companies in the show notes and also on the internet. So if anyone in our audience does have any legal queries or concerns in terms of what we've raised today, that they can contact you individually and directly. So guys, that was great. I learned a lot about the directive today. I think there's a lot of problems there, but also some opportunities to your point, Julie. And thank you very much indeed to your audience for joining us. So guys, have a great afternoon and day ahead. And thanks ever so much for joining us, everyone. All the best.
Thank you for inviting us.
Thank you, Lucas. Thank you, Julie. Thank you to your audience. Goodbye, everyone. Thank you.
Bye-bye.
Bye-bye.